School and the University of Oxford. It promises to be a fascinating day of discussions, as you can see from the various sessions and the speakers we have lined up for you. On behalf of the Vice Chancellor, I'd like to apologize for his absence. He's been called for Board of Governors duty at a central university and he had to go, so he sends his apologies for not being here today. This is a very important opportunity for NLU Delhi to collaborate with institutions like the Melbourne Law School and the University of Oxford in attempts to strengthen and further public law scholarship in India, and I hope this conference will contribute towards that. And I'd like to thank all of you for showing interest, registering, and coming from all parts of the country to be here today with us. We really appreciate your time and effort. As you can, since some of you may not have the schedule with you, I'll just quickly take you through the sessions. The first session is on transnational engagement with the Indian Constitution. Then there's lunch from 12:30 to 1:30. The afternoon sessions are on separation of powers and religious freedom. And the last session is on the death penalty. So I do hope all of you will take a lot away from this conference, and please do, there's sufficient time reserved for questions from the audience, so I hope all of you will actively participate in that. Now, if I may call on Farah, Tarun, and Cheryl to introduce the conference.
Thank you very much, Anu. So Cheryl, Tarun, and I are just going to introduce the conference, mostly by just talking a little bit about the vision that we had for this conference and why we decided to bring all of these people together here at NLU. I'd like to actually begin by acknowledging the many people whose support was vital to organizing this conference, and in particular National Law School, National Law University Delhi, and Anu Surendranath, who you've just heard from, and in particular the Vice Chancellor of NLU Delhi, Professor Ranbir Singh. We'd also like to acknowledge the very, very generous grant by Alan Myers QC to the Oxford Law Faculty and Melbourne Law School. Without all of these people, this conference just could not happen, and we're very, very grateful to them. I'll now turn over to Tarun, who will talk a little bit more about the vision that we have for this conference.
Well, as the Oxford leg of this three institutional collaboration, unlike Melbourne, Oxford doesn't yet have an Asian Law Center, and this is a strong hint to my Oxford colleagues to think along Australian lines here. But it does get a very large number of bright Indian law students, many of whom are supervised and taught by people in this room. Today, my own supervisor, Nick Bamford, is one of the speakers scheduled for later today. So there is institutional interest in Oxford and Melbourne in Indian law, which is why this has happened. But from the Indian point of view, I think India has had a long-standing tradition of engaging with transnational law from the very moment of the founding of the Indian Constitution. With the famous Gandhi-Tagore debate between looking in and looking out, we've had a tradition, a skeptical tradition, of engaging with the world. Of course, I say the world, but certain parts of the world. And just like today's scholars, again, many of whom are in the room doing their graduate degrees abroad, many of the founders, like Dr. Ambedkar and Pandit Nehru, were influenced by their own global movements and by their own institutional affiliations, which then left an imprint on the shape of the Constitution. We also realize the dangers of comparative law and comparative law scholarship, and the need to do it carefully, and the need to locate it in indigenous particular context. So we are very grateful that we have Professor Bakshi and Professor Singh amongst others in the crowd who will bring their long-standing engagement and knowledge of Indian legal scholarship to this debate. So, although the Indian engagement with global legal scholarship has been long-standing, the opportunities that exist today, the scale and size and shape of the opportunities for this engagement, I think are new. Sometimes it is simply a matter of having the funds to travel to international conferences or to bring people here. So with that opportunity, what we hope to do today is simply to take yet another small step to facilitate a cautious conversation on India's engagement with primarily, given our speakers, British and Australian law, fully aware of its pitfalls and possibilities. So that's all I want to say.
Thank you. Well, my task is partly to make the point that this conference is also a roundtable of the International Association of Constitutional Law, and to welcome you here on behalf of the IACL. My credentials for doing that is that I'm a former president of the IACL, but I should say that I speak on behalf of its current president, Manuel Cepeda, who is the former very distinguished president of the Constitutional Court of Colombia, and my own colleague, Professor Adrian Stone, who's the first vice president of the association and one of the organisers of this event, the director of our Centre for Comparative Constitutional Studies, who's very sorry not to be here doing this herself today. And if I might take the opportunity to say a little bit about the IACL while I have you all beautifully captive, that would be much appreciated. The IACL, as its name implies, is the world body of constitutional law. It has members in all regions of the world. It runs a number of regular events, one series of events that are called roundtables, of which this is one, smaller events focused generally on the constitutional law of a particular country, but very often from a comparative perspective. And it also has a World Congress every 4 years. The next World Congress is scheduled, I think, for 2018 and will be held in Seoul in South Korea. And so I'm sure you'll hear more of that in the fullness of time. The IACL, as you can imagine, with a body like that that has members from so many different constitutional systems, is constantly struggling with ways to ensure that the constitutionalists of the various member organisations are genuinely able to talk to each other and not past each other about their constitutional arrangements. And from that perspective, I think they would be very proud of the event that has been run here in Delhi over the last few days. The workshop format that we've been using for the past 2 days has genuinely enabled people to engage and to ask each other questions in a way that is very hard in many more standard constitutional events. And I very much hope that today will operate along similar lines, and certainly Farah and Taran have gone to great lengths to make sure that is so. The IACL has various categories of members. It has national organisations of constitutional law as members. It has specialist institutions of constitutional law as members, and it has a range of individual members. And if any of you are interested in individual membership, can I encourage you to go to the IACL's website, download a membership form, bung it in, and they will be extremely delighted to hear from you. The executive of the International Association has had a string of very distinguished Indians as members, beginning with Soli Sorabji in the very early years of the IACL's existence. But one thing that it occurred to me I might encourage you to think about when we're here is whether you might consider establishing an Indian Association of Constitutional Law as a national member of the IACL. It always sounds like an enormous undertaking to establish a national association, but actually the Australian experience is that it's easier than you think, and that it attracts very considerable interest. And one option for those of you who are here is to think about forming a national association, to use that as a forum in which you can exchange views within India itself, but also use that as a platform with which to engage with the constitutionalists of the world. So I very much hope to see you in Seoul, hopefully flying the banner of the Indian Association of Constitutional Law. So thank you very much again on behalf of the IACL, and can I add my thanks to Faraz for all the people who have worked so hard to make this event such a success. My own colleagues at Melbourne, including Professor Pip Nicholson, who's here, and we'll hear from her later today, from the ALC, the wonderful, strong, collegial Oxford contingent, and of course the people at the law school here in Delhi who have worked absolutely tirelessly to make all the arrangements as smooth as they have been. So I hope you really enjoy the rest of the day, and we will look forward to an exchange of views.
Although in view of the fact that I am doing public comparative law as well as legal systems, I should have not raised this kind of doubt or question, but in view of the fact that some of the questions which were asked initially, I think there is a need of understanding the Indian public law as well as Indian legal system properly on our part, as well as on our friends on the other side who are trying to develop a comparative law vis-a-vis India. That there are dissimilarities and stark dissimilarities as regards the comparisons. And for that reason, therefore, like for example, although of course maybe Paul will not like that expression to be used, but by and large, and specifically so far as common law is concerned, it's a bottom-up model of law, the way it has been made. So far as India is concerned, it is top-down. The common law was just brought in here without regard to what the earlier law in the country was. And it is that law which we are now enforcing without trying to understand what exactly the Indian legal system and the Indian people are. Now, again, in the present scenario, political scenario in the country, I should not refer to Caste Disabilities Act, which you are referring more than once. It was nothing else but to facilitate conversion. I don't think it was made for any reform in India. And therefore, any reform, if they have been made first time by the Constitution of India. And we should try, therefore, and your support also should come to help us in understanding our own legal system, rather than just become the followers That is, we are left behind, and we have just to follow. That we develop a system in which we cannot make any contribution either for ourselves or for the society in general. Rather, we are just followers of what is happening in other societies. Sorry for raising this kind of question, but I thought it became necessary.
Thank you, Professor Singh. We've had these conversations in person before, and I think, let me start by saying I'm surprised if my presentation came across as saying Indian law is backward and it should follow what the Canadians and the South Africans and the British are doing. Maybe it is a 15-minute format that does not allow for the nuanced necessity to make these points subtly enough. If I was talking on a different topic, for example, multiculturalism, I would probably say quite the opposite, that I think the country I live in, the United Kingdom, has a huge amount to learn from Indian practice in the last 60 years. As in debates that are done and settled in this country and are sort of taken for granted are only beginning to emerge and just not understood in the UK. Right? So I think it depends on what the topic is, right? And it depends on what is being talked about. I think the Indian experience with affirmative action has a lot to teach as well. If I was talking to a British audience or an American audience, I would probably dwell on that. But that does not detract from the point that Indian discrimination law, that the protection against discrimination in Indian constitutional and statutory law is by and large abysmal. And that there are other places that have done a good job, not a successful job, not a perfect job, but a reasonably sincere effort to deal with the question, and that I suspect you agree with me that the problem of discrimination in India is not deniable. If it is an urgent problem that needs addressing, then looking at places that have tried to address that problem is one of the many things we need to do to understand how to respond. Right? So I don't know what the import of the suggestion to understand Indian law was. I suspect my claim that Indian discrimination law is underdeveloped, moribund, ossified, is based on an understanding of Indian discrimination law. It may be a wrong understanding, and I would obviously welcome. It is, of course, a general claim. You're absolutely right on the Caste Disabilities Removal Act. I think I said in my presentation that it is based on an anti-conversion, on a pro-conversion doctrine, but it could be used differently today. And there are similar contextual stories that could be talked about each of the developments that we have tracked. But having said that, I think I would reiterate the bottom line, which is that I think the claim that I make is about Indian discrimination law is, I hope, an informed one, and hopefully we'll continue our conversations where I look forward to learning where I have been ignoring useful information. Thank you.
Can I also say something about this? I'm really glad that Professor Singh raised that point for a couple of reasons. One, the point you make about really understanding, everybody needed to really understand their own system, I think is absolutely right. I think that we know as constitutional lawyers that nobody really understands our own system better than we do ourselves, and there's a whole lot goes into that, the depth of understanding, the integrated understanding. And in fact, one of the advantages of comparative law, I think, is that it can enhance your understanding of your own system by seeing it in contrast with others. So I'm extremely glad that you made that point. But I would also be sorry if anybody thinks that this session is about India catching up. On the contrary, I regard this session as us all talking about the shared enterprise of comparative constitutional law in the world of the 21st century, and it's more of a shared enterprise than ever it was. It's a world in which we are all borrowers and we are all lenders. And if you think about it, India's a big lender. I mean, it's a big lender in South Asia. It never ceases to amaze me how sort of the basic structure doctrine and all the others emanate out. But it's not only South Asia. I mean, South Africa was influenced by the directive principles. As I said, Australia has started looking at Indian experience to try and understand itself. Whether it actually adopts it remains to be seen. And in fact, Paul's very interesting development of the external notion of autochthony was drawing on basic structure in a very creative way. So the time has long since passed when we all need to feel humble and think that we're importing stuff from elsewhere. This is a world of a lot of to and fro, and the question is how we go about it and how much we preserve of ourselves in the process.